I'm Sarah with Phillips Law, a criminal defense firm based out of New Orleans, Louisiana. Today we're talking about something called a motion to quash. And just to clear things up right away, it's motion to quash, not squash. I know it sounds strange and we hear people mix it up all the time, but in legal terms, to quash means to cancel it, shut it down, or throw it out. And that's exactly what we're asking the judge to do, to throw out the charges. So again, not a squash, it's a quash. So again, what is this motion to quash? A motion to quash is a formal legal request asking the judge to dismiss the charges against you because something about them is legally correct. It isn't about what happened or what you're accused of. It's not about guilt or innocence. It's about whether the DA filed the charges the right way, whether they followed the rules and respected your rights under the law. If they didn't, we have the right to ask the court to quash the case or dismiss it. So why would we file a motion to quash? There are a few situations where this usually comes up. For example, the charges were filed too late. Every crime has a deadline called the statute of limitations. If the district attorney waited too long, the case might be legally expired and we can ask the judge to toss it. Another reason is the paperwork is flawed. For instance, if the bill of information or indictment doesn't clearly say what you're being charged with or is missing required any details, well, that's a problem and they need to correct it. Another one would be double jeopardy. If you've already been tried for this or something closely related and the DA can't charge you again, that would be unconstitutional and we can challenge it. Another one is if you weren't properly served. So if the state didn't notify you the right way or didn't follow the timeline they were required to, we might be able to quash the case on that basis. Again, that's kind of rare, but again, an example. So this motion is really about holding the district attorney accountable. Did they follow procedure? Did they meet their legal burden from the very beginning? So at a motion to quash hearing, we argue our position in front of the judge. Sometimes it's as simple as reviewing the documents and legal timelines. Other times we need to bring in witnesses to help clarify about what happened and when. Of course, the district attorney is going to get a chance to respond and then the judge makes the decision. Do the charges stay or do they go? Some people kind of say, is this a dismissal? Yes, kind of. If the judge grants the motion to quash, the charges are technically dismissed. But depending on the reason, the DA might have the option to refile the charges later, especially if it's something they can fix. In other cases, it's final and the case is over. But if it's just a simple mistake, the district attorney can refile. Either way, it's good for us because it can buy us time, it can create leverage, or even in the case before it goes to trial. A lot of people want to know, will I have to testify at this? Probably not. Motion to quash hearings are usually based on legal argument and court paperwork, not necessarily testimony. So most of the time, we're going to handle it. You'll be present in court, of course, but you won't need to speak unless we need to talk to you beforehand, and usually that's really rare. Now, why does this matter? Because in criminal, the details matter. If the DA makes a mistake, and they often do, we're going to catch it and make sure to take all the legal action we can. A motion to quash is one of the easiest ways we can fight back. Before we even talk about evidence or trial strategy, we need to step back and say, hey, did they even file this case properly? If the answer is no, we're going to say so, and we're going to ask the judge to shut it down. It's about holding the DA accountable and not leaving any stone unturned. So if you're a current client and you have a motion to quash hearing coming up and you have any questions, again, don't hesitate to reach out. We want to make sure that you are aware of everything that's going on. If you're not a client but you're facing charges in Southeast Louisiana and you're thinking, man, I want a lawyer who can explain this to me, give us a call at 504-395-8867. We'll talk to you for free and let you know exactly how we can help you out. So thank you so much for watching, and check out the rest of our video series if you want to understand more about the criminal court process and how we fight for our clients every step of the way. Thanks so much.